Hi guys, it's Kathy. I hope you're doing well. Man, you guys fill up the comments fast. You know that. That's awesome though. That is awesome. I don't know. I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 clips today. So I can't play them all or we'll miss Fleischer. But I already played one of them. It was the intro clip, which I got back by stealing it from myself from YouTube. I know I need to make a new intro, so nobody tell me that. I did start one today, and then I just trashed it because I didn't like it. I had other things to do today. So, I don't even know where to begin, guys. You're going to get really, really mad at some of these. One of them, the most taboo word I can throw out is coming out. And I just want you all to behave. What? What's going on? I don't understand. Someone tell me what's happening. Is it too loud? I need more descriptive words, people. I need more descriptive words. Am I too loud? Do I need to turn my volume down? Okay, fine. If Fozzie says it's fine, then Fozzie says it's fine. Yes, you do. You have to see. Yeah, doesn't it say court vibes right over there? I can see it. Hold on. I'm going to go to my. I can see it on my YouTube channel. Listen, guys, we don't start the hard drugs until halfway through the show. I'm not always going to trust Fozzie, Jacques. I'm just not. Did you not? Okay, I'll play the intro again. Apparently, somebody missed it. We hate that. See? There we go. Okay. All right, Kelly, I'll do it one more time. No, just kidding. These are not the droids you're looking for. There is no intro. Okay. So, let's just start. Guys, I don't know where to start. There's so much. All right. We're going to start easy. It's just an interesting case. Nothing crazy happens. It's just an interesting case. We'll start there. That's easy enough.
Good morning.
Good morning, Your Honor.
Please state your name for the record.
Amelia Hollis.
Good morning, Ms. Hollis. I'm Magistrate McDonald. This is case number 5024.
John Moran, attorney with Ms. Hollis, will waive any further advisement as to address bond, please.
Thank you. Mr. Colquitt, people's position for bond.
And Judge, again, noting I didn't have any CPAT, but looking at her criminal history, it is fairly limited. Does all seem to involve alcohol. What we would ask for is a no contact protection order for the named victim in the case, Tyrone Treweek, date of birth 12/26/96, adult white male. And we would be seeking a small cash or surety, $500.
All right. And this is a VRA case. Is the alleged victim present in the virtual courtroom?
He is not, and we've reached out to him. We've been unable to make contact.
He's present. John Hollis. Although with the way it was charged, I guess it is a little confusing whether
John's not the victim.
Well, there was an allegation of a smashed telephone, and that smashed telephone was linked to Mr. Hollis. So
that is correct. Who, if I recall correctly, refused to provide a statement or come outside. So all that being said, Mr. Hollis, this is Magistrate McDonald. Is there something you want to share with the court?
We just like to have her home. I've got a tie with me here as well. It's not up there.
All right. Is there anything else?
Uh, just we love her, and we'd like to have her back home with her baby. So,
All right, thank you.
So, Your Honor, when he's describing Ty, that is Tyrone Traweek, the individual named by Mr. Colquitt as the victim. So, if it's helpful to the court, perhaps we have Mr. Hollis put Mr. Tyreek on the phone. I would not dispute the characterization as of alcohol having been on board. I think that to ensure community safety, that an alcohol restriction would do the trick. There's no need to keep her in custody on a cash or surety bond. She does have a 4-year-old daughter. Daughter is at the house with Mr. Tyreek and Mr. Hollis. They desperately want to have Ms. Hollis come home. By the request for a no contact order, the home is the only place Ms. Hollis has to go. It sounds like she's going to really struggle to find any other adequate housing for her and her child. The house, as she describes it, is apparently in her name. It's her place. She pays the bills on it. Though I was discussing with her the way a no contact order would work is that the named victim remains in the house, which is going to be a real struggle, I think, not only for Ms. Hollis, but for Mr. Tyreek and for Mr. Hollis. It, I think, bears mentioning in this case that it was in fact Ms. Hollis who called the police. She was feeling scared. I don't know if she was properly perceiving threats, given the allegation that she had been consuming alcohol. She will refrain from the use of alcohol as the case is pending and until old enough to do so. She was born in Cortez. She did move briefly with her father, but moved back to Cortez with her dad 4 years ago. She's a single parent. She's not getting any child support. She's supporting her child and the household with her job as a CNA at Vista Mesa Senior Care Center. She's a supervisor there, which I think demonstrates the level of responsibility this young woman can be expected to demonstrate when required to do so. She's due at work on Monday. Graduated high school, obviously. She's currently in college at Pueblo State Community College. Only has 7 classes left for her business degree. She describes having a lot of homework she needs to be attending to this weekend. I was picking up a lot of shame in having participated in a situation that led to this place, though she was herself in fear. I think that Mr. Tyreek and Mr. Hollis's lacking cooperation with law enforcement is indicative of there being more to the story. What John Hollis, the father, described to me is that he would absolutely, I put this in quotes, absolutely accept her back in the house. He is not concerned, what he was describing his safety. He's not concerned for his safety, the child's safety, or Mr. Tyreek's safety. And perhaps it would be helpful to the court to have Mr. Tyreek weigh in on this. But my big concern is, one, that a cash or surety bond is going to take money that otherwise would help to support that household, would otherwise help feed that 4-year-old little girl. I don't think that that's a useful way to spend money here. And what will ensure return to court and community safety is an order requiring her not to consume alcohol. As mentioned, she's good at following orders. She does for a living and supervises other people who do that for a living. I'm confident she'll be able to do so. We're requesting a non-harassing restraining order and a personal recognizance bond.
Colquitt, anything further?
I'd submit it, Judge.
All right, well, here's a question for either counsel. Please respond as you deem appropriate. What pretrial services are currently available in Montezuma County? Because I'm under the impression that there are none.
They're still ordering them here, Judge. It's in limbo. I'm hopeful that they're going to keep it, but I'm hearing rumblings that there's no funding for it. So we would like to see it ordered if it can be enforced.
My information is that the sheriff is representing to the county board that he has been defunded and that pretrial services was one of the programs that he cut. I think at the moment there is not pretrial services available. I do think that there's a movement afoot to have judicial and perhaps probation provide that if the sheriff won't, but I think Your Honor's information is accurate that we don't have a pretrial supervision arm of the sheriff's office, at least.
So, Mr. Moran, hence my concern is that I can order all kinds of great things, but in the absence of someone to actually do the testing, how are we going to ensure the safety of the alleged victims and, quite frankly, the 4-year-old?
Your Honor, this may be another thing that we could have Mr. Hollis weigh in on. My suspicion is that for the peace of that household, that law enforcement will be contacted by either himself or Mr. Tyreek if alcohol is consumed. Know that that's not directly answering Your Honor's question. It's unfortunate that we don't have the means to have law enforcement providing the court that assurance, but
Well, let me interrupt, Ms. Moran. Ultimately, during the investigation, Mr. Troweek refused to allow the officer to take a photo of the door that allegedly hit him in the eye that was broken. Mr. Hollis refused to go outside and provide a statement. I really am profoundly concerned that at some level, these alleged victims are not through by contacting the authorities should there be an incident of alcohol consumption. At some level, it sounds like there is some codependence here and some unwillingness to mandate some repercussions. And so I'm struggling to find a path forward that doesn't put this defendant on the street, but by the same token, if the genders were reversed, I don't know. I think that our society assumes that all victims of domestic violence are women, and I would respectfully submit that my concern here is that we have a victim or victims that are not, and as such, I am concerned for their safety.
If I could weigh in on this, my name's
Please.
Tyron Treweek.
Hi.
I am on probation as well, and I've been completely sober for about a year now, and for one, I do not want her to consume any alcohol. I've been against it for a while now. It's almost an ultimatum of mine. If she drinks, then I don't even want to be around her. And she doesn't drink often. I think that she's ready to be sober as well. Just after everything that's happened just recently. And I also think that she was ready. She's ready to be sober, and I don't know. I just think she's ready. So
Ms. Hollis, you gonna drink?
No, Your Honor.
You know, there's a lot of reasons that we have an age limit for alcohol consumption. Some of them are maturity levels, some of them are part of the neuroscience of the development of the brain. But ultimately, quite frankly, if they're going to set a limit, they should set it at age 25, not age 21. That being said, we are in a curious situation in that if there were pretrial services available, certainly this court would be far more confident that the community would be protected. In that community, I mean, Mr. Treweek and Mr. Hollis, and quite frankly, your 4-year-old daughter.
Is there pay for our own drug testings voluntarily and turn them into the court or something like that?
That's a great question. I don't know the answer for that, Mr. Treweek.
I do know that you
would
can
be
voluntarily,
scram
you can do it at the PARS, the recovery center. I know you can voluntarily do it. I just don't know how we would turn them into you or how that would work.
I apologize, Mr. Colquitt. You were saying what?
She could always be put on scram.
Scram's an expensive proposition. I'm a big fan of Scram. And I don't think this is quite a Scram case yet. So let's hope that it's not going to become one. What I will do, Ms. Hollis, is I'm going to order a $1,000 PR bond. Ultimately, if you drink, you're not going to be out on PR bond going forward. No zero. No illegal drugs. No recreational marijuana. Monitor sobriety is directed by pretrial services to the extent possible. Random BAs. You must remain law-abiding at all times. Because you're alleged to have violated the Title 18 charge, you are subject to a mandatory protection order pursuant to CRS 18-1001, which will remain in place until final disposition of your case. Pursuant to that order, you shall not harass, molest, intimidate, retaliate against, tamper with any witness to or victims of the acts charged. Because you're being charged with a crime that's alleged to be an act of domestic violence, it's a condition of your bond and a condition of the protection order that you neither possess nor receive any firearms or ammunition during the period of the protection order. If you have firearms or ammunition, you're required to relinquish them within 24 hours of your release. You'll be provided a packet of papers that you need to fill out in the context of relinquishment. You have to return those to the court within 7 days. Failure to either relinquish the firearms or ammunition or failure to return the relinquishment packet to the court within 7 days may result in your bond being revoked, may result in your charges being filed against you, and or may result in you being held in contempt by the court. As to the no contact, I am struggling here. And I am not going to order a no contact. Simply the shall not harass, molest, intimidate, retaliate against, or tamper with language. Again, Ms. Hollis, in the simplest of terms, if you violate the bond and or the protection order, it is highly unlikely that you will be in the same position vis-a-vis the no contact, quite frankly, vis-a-vis your freedom. That being said, having the named victim and the second victim present with us in the virtual courtroom does give me some level of comfort, even if it's only such that I think that there may be some family dynamics there that need maybe some professional help. But with all that being said, your return hearing date, Ms. Hollis, is June 5 of 2024 at 9 a.m. in courtroom 1. Is there anything further, Mr. Colquitt?
No, Judge.
Is there anything further, Mr. Moran?
Your Honor, thank you.
Ms. Hollis, good luck.
Thank you.
So I just thought that was interesting all around, all over the place. That was interesting. They don't have enough resources to deal with someone who has an alcohol problem. I mean, she only has an alcohol problem. She doesn't drink every day. I guess she has a domestic violence problem and a parenting problem and an alcohol problem and a telling the truth problem and a whole bunch of enablers problem. And now she has People who have seen her on YouTube problem. Oh man, I don't know where this is. Can't remember. I mean, it's Colorado for sure. I just can't remember where in Colorado it is. Trying to say, oh, it's Montezuma. It is Montezuma, Colorado. Colorado's trying, guys, but ooh. I don't even know where to begin with that. I don't know that one. I sure like to meet her. Or not. Or not. You know, it's fine. It's by Durango. Just so you know, Montezuma is by Durango, if that helps. That's the same to me. Okay, I'm just going to get the taboo word over with. So, mods, get ready. We're going to poo-poo comments that we don't need to hear or see. We don't need comments on the taboo word. You can comment on everything else except the one taboo word that he says. All right? I'm going to poo-poo every comment that I see. I really am. I'm still going to play a video, though. Here we go.
1187 a.m. Nevada County warrants. Fraud. Fraudulent use of people's ID 18 to 60 and swindle 20,000 to 50,000. According to this, your bond is set at count 1 is 3,500 and count 2 15,000 for a total of $18,500 with conditions: no contact directly or indirectly with the victims. Co-defendants, witnesses do not possess or consume any alcohol, illegal drugs, or controlled substances without a valid prescription. Do not possess any weapons or firearms. Osceola County, if you don't bond out, Osceola County has 24 hours to pick you up starting now. Do you have any questions?
I do have a question.
Make sure it's a question and not a statement, because anything you say could be used against you.
How do they charge me for a crime when I've been out of the United States of America for 14 years and I flew back to see my dying grandma and they arrest me on an airplane, but I've never violated a law? This is not going to be a Trump stunt witch hunt with me when my dad's a U.S. Senator and I have a diplomatic status. I'm not going to play that game in the state of Florida. I'll go right to the governor.
Is that a rhetorical question or was it an actual question, sir?
I'm asking you that as a judge. How do they do that in the United States of America?
I don't know. I'm not an Osceola County judge.
I'm not happy. I can tell you that when I was on that plane going back to Costa Rica. My wife's 8 months pregnant.
Good luck, sir.
This way.
I mean, I don't know. I could be spitballing here. 7 state offender, theft, fraud, obtaining money, false pretenses, fraud, insufficient funds. I don't know. Your name, sir?
But he's going to contact the governor. He's going to contact the governor because he's never broken a law. How do they just arrest someone on the plane when I've been on the run from the law for 14 years? You can't arrest me. I was in Costa Rica hiding. I mean, my grandmother was dying. No, I'm not going to say the word if you guys didn't pick up on it. I'm sure some of you did. Okay. All right. No, it was Trump. He said the word Trump, like Donald Trump. We live in the world with Donald Trump, so I guess we're going to hear that name sometimes. Okay. Oh, thanks, Rebecca. I should have said that 3 minutes ago. All right. We're going to go to one that's just going to make everybody in here mad, probably for different reasons. Every single person is just going to get mad. I mean, just warning you now. If you don't want to get really, really angry, go pet a bunny. Go pet a bunny. Here we go.
012927 on arraignment on a violation of probation. Count 1 alleges that you failed to report to probation at such times as directed. You also have case 24 FD 008248, offense date July 31st through August 3rd, 2023. Count 1 alleges child endangerment in violation of Penal Code 273A, A. Public defender is appointed.
Thank you, Your Honor. Warren, Public Defender's Office, will accept appointment with formal arraignment and further advisory rights. I am requesting the court release Mr. Monte on pretrial release level 5.
For the record, the people are objecting. I'm very concerned for public safety and the safety of the child in this case. It is our position that detention is necessary to protect the child who is very young and ensure that child's safety as well as the public safety, and that there's no less restrictive measures or alternatives that would vindicate those interests. I ask the court to consider the seriousness of the charged offense, the facts of the defendant's criminal history in order to protect the public and the victim. In this case, law enforcement received a call regarding a child falling from a high chair. Officers respond and they see that the child is unconscious and barely breathing. They have to perform CPR on the child. The child is later transported to the hospital. That baby tests positive for fentanyl. There is a fentanyl overdose, according to the nurses, and not once, but 4 times while this baby was in the hospital. This is a very serious fentanyl overdose. The defendant, along with the co-defendant, it is alleged that there was fentanyl in the home that this child had access to. The officers conduct a search warrant at the defendant's residence, at the apartment. The officers note that the apartment was dirty, disheveled, unkempt, smelled like smoke, that was littered with paperwork and prescription and counter medications in the apartment. The officers locate a blender bottle with fentanyl residue inside that blender bottle. During the course of investigation, officers also indicate that through their investigation, they see text messages between both defendants regarding this defendant buying, selling, and possessing fentanyl as early as the day before this child suffers an overdose for fentanyl. This child could have died, and this defendant put that child in danger. This is a very serious case. The defendant has a very serious criminal history as well. He has a recent prior strike. It's a robbery, a PC 211 from 2022. He also has a PC 211, another strike from 2003. I would note as a juvenile, there is a homicide that is noted on his criminal history from 1987 as well. Along with this defendant's criminal history and the facts of this case, again, the people are very concerned for public safety and ask the court to have this defendant remain detained for the child's safety as well as the public.
I will note Ms. Galava's objections for the record. I think it's important to court note that the charges stem from the summer of 2023, that the complaint in this case was not filed until May of 2024. As part of the consideration that the court took into account was the fact that the defendant had been left out of custody without, as far as the court can see, any other criminal activity in the 11 months that transpired since this case. The court also has taken into consideration whether or not there are less restrictive means that can be imposed on the defendant in order to ensure the safety of the public. The court believes that there could be, as long as the defendant complies with the terms and conditions that they are placed in. In this case, I will place the defendant on pretrial level 5. You are ordered to have 2 check-in phone calls per month, in addition to you are required to provide your current address and phone number. You change your address, phone number, or employment status, you need to let pretrial services know. immediately. It is your responsibility to make sure that pretrial services knows how to get a hold of you. You are required to obey all laws. You are subject to search and seizure of your person, your residence, and your vehicle by any peace officer without a search warrant. You are not to use or possess any illegal drugs. You are to submit to drug and alcohol testing. You are to have no direct contact with the identified persons except in compliance with the court order. No contact includes, but is not limited to, any of the following: no texts, no phone calls, no online messaging, or written contact with the protected person. I'm going to go over who that is in a moment because there's also, in addition, a written no contact order here for that same individual. Greasy, Breezay, Monte, spelled the same as the defendant. You are ordered to have no contact with this individual under the same terms as I've indicated. That includes no contact through a third party. You are allowed to contact through your attorney under reasonable restrictions placed by the court. That means you are not to go within 100 yards of their home, workplace, vehicle. You understand and accept the terms and conditions of your release. You are ordered to return to court
June 17th, 8:30, Department 63.
June 17th, 8:30, Department 63. Sir, you have to make all your court appearances. Do you understand and agree to do so? You are also ordered to report to probation in person no later than June.
He has not been in custody for 11 months. This happened 11 months ago. He is now only getting charged with it, and the mother. The mother and him are now only getting charged with it. They didn't press charges until now. So they've had this baby for the last 11 months still. I guess they took the baby home from the hospital. I guess. I don't know. The baby is no longer with them. So they don't have the baby anymore. The baby's safe. They're not allowed to talk to each other. They're not allowed to contact each other. And now they're going to get charged for this. And who knows what the charges are going to be. But yeah, I don't know where CPS have been for the last 11 months. It's crazy that they've had custody for the last 11 months. And oh, well, he got no more charges in that time. That doesn't mean he didn't do anything wrong. It just means he didn't get caught.
Yeah. You understand and agree to do so?
Yeah.
One moment while you're served. We have an officer who can serve the defendant. I was like, wait. Sorry. No. Here is his turn.
He's on level 5 probation. Yes. I know that.
Then that'll conclude the matter.
Hi, Heather.
Last but not least, page 6.
So this has been all day long. All day long. Here, look. This is Florida. These are quick.
Your name, ma'am?
Samantha Jones.
All right, you were here in 24 CF 7592AO, possession of oxycodone and battery domestic violence. Review the affidavit. Found probable cause, appoint the public defender. Your name, sir?
Raymond Reed.
Is there anything that you want to tell me? Anything you think the court should consider in determining conditions of her release?
Like I said, my main concern right now is my daughter's safety, and I know due to the fact how violent that she is, and I haven't been receiving threats from her plus her family members, and I don't want my daughter to be in a position that she needs to be in with her. I just want to see if it can make concern until further notice that my daughter can stay with me until you guys feel like it's okay for her to go. But right now, my daughter, she's scared to even be with her mom right now. And I know how violent that she is. That's the reason why I'm here right now. So I don't know if you guys can help me right there until further notice. And I do want to file a injunction. Well, I am want to file an injunction against him.
All right. State, do you have any questions for him?
Are you afraid of her?
I have been receiving threats from her and her family. Yes, I have.
Has anything like this ever happened before?
No, ma'am.
There's no further questions.
Defense?
No questions, Your Honor.
Any input from the state?
She qualifies for PTR, Your Honor. State has no objection.
State or defense?
And to file an injunction, you have to go downtown to the main courthouse to do it.
Yes, I'm
You
going.
can't do it here.
So who do I need to speak with as far as in my daughter's safety, as far as in
That would be civil, so you might want to talk to a family attorney.
I have one.
That would be who you talk to, and they could talk you through that process.
Okay.
You sure?
They're not putting a no contact on.
Okay. Count one, I'll set at $1,000. Count two at $100. No contact, no return, separate. Do not possess any guns, knives, or weapons.
So she can't be around him, but she can still be around her kid. And then the next one.
Ma'am.
Denise Grant?
24 CF 7609 AO, one count of child abuse. Were you interested in the services of the public defender? Did you want to represent yourself or hire a private attorney?
So I'll start with the public defender and then I'll find another
All
attorney.
right, yeah, never mind, I'm sorry. They're hiding this from me. I'll go ahead, I'll appoint the office of the public defender to represent you at found probable cause. Your name, sir?
Robert Ferreira.
All right, sir, is there anything that you want to tell me, anything you think the court should consider in determining conditions of her release?
Come home, she could go home, but if I can have at least like custody of my kids right now.
I'm sorry, if you get a little closer to the microphone.
If I can have custody of my kids right now, because right now we're on case, and I think that my kids are way safer with me than with her at the moment. For the time being, I mean, if she can go home, she can go home, but I don't live with her. I have separate residence. I mean,
State, do you have any questions for him?
Are you fearful for your child's safety?
yes, I am. I am worried about their safety.
Other than this incident, have you noticed any prior incidents?
Yes, this is like the second incident that we've been having.
The state has
I
no.
get them. I usually get them on the weekend. They're with them during the week. But if I can have custody with them throughout the week, I have no problem with that. I'm just worried about their well-being.
State has no further questions, Your Honor. We'll just ask for no contact with Leilani, the 8-year-old, the alleged victim, and to comply with DCF in case they change or put in a case plan in place.
Anything from the defense?
Your Honor, I would ask that she be allowed to return home. The child is not there. And Jeff is already involved with the case plan. So just ask that she.
All right. I'll set your bond at $4,000. No contact with the alleged victim. Abide by conditions of DCF. Do not possess any guns, knives, or weapons. So, sir, by virtue of me issuing a no contact order with the alleged victim, you'll have custody. Now, if DCF makes any changes, whatever DCF says, we're going to follow. So if DCF says she can have contact, then contact's going to be allowed, okay?
That's all.
All right, because they're going to be able to do a better investigation than what we just did right now.
All right, no problem.
All right, do you have any questions?
Oh, no, that's it.
All right, thank you.
Thank you.
Thank you, ma'am.
Finally, no animals today. No animals today. Fozzie's working too hard to be in here. Okay, I'm going to go back to an interesting case. So, it's just lawyer talk. So this next few minutes is just lawyer and judge talk. No craziness. The reason why I tried to record this one is because there was this case that was coming up today where this guy owned a clothing store, right? And he got sent to prison. And while he was in prison, his wife, ex-wife now, who's divorcing him, locked up the clothing store, sold everything, got rid of everything. And when he got out of jail, he came in to a empty clothing store. Nothing was there. He said he lost $85,000 in merchandise. Well, sorry, my dog's protecting me. So he didn't sue the wife or the ex-wife, right? He sued the owner of the building. So he's dragging this case on and on and on, suing the owner of the building. Yeah, there's a Fleischer stream coming up. There is. It's coming. It's always last because all the people have to get in. It takes them an hour to get in. Anyway, so he was supposed to come today, and that's what I was trying to get. And he never showed up. I was so excited for it because he wrote the complaint like it looks like in crayon. It's not in crayon, but he handwrote this complaint, misspelling words and sideways words, and on the side of the paper. It was so good, and he just ruined my day because he didn't come. But while I was looking, I found this.
Good morning, everyone. This is Magistrate McDonald. Today's date is June 2nd, 2024. The time.
And that's the wrong clip. I found this.
We filed a notice of deposition against the defendant, and we've asked for a production of certain documentation that we think is absolutely imperative. As you heard when the defense counsel initially introduced herself, she indicates that the name that appears on the complaint is not the individual's actual name, that his name is a different name. But this is one of two names that he gave on the police report. So physically in the police report, this is the name that he is identified by and identified himself by. He also, in speaking to the police, gave a second name, and we've learned from the insurance company. I have at this point in time, I have 5 different names from his insurance company, the police report, his residence back in New Jersey. He claims to be living in New Jersey, but I received an affidavit indicating that he lives in Massachusetts. This is completely a moving target, and this is a huge case. This gentleman took a left-hand turn in the middle of the night, or at 7 o'clock, and hit my client on a motorcycle and amputated his foot. So we're asking for all of the information about who he is, where he is, what he owns. There's at this point, all of the information that I put in the notice of deposition I'm looking for. And I don't think because it's a car accident doesn't mean that we're not entitled to be able to identify who he is and be able to explore all of that information as well, especially in light of the fact that we've got so many different, I'll call them aliases for this gentleman. The fact that he's from out of country, I think, is also significant. We should be able to.
Why is that significant?
Because he may have assets in another country. I'd love
that's for a motion for determination of assets. That's not a discovery issue. If you have a PJR, you get your PJR, you want a disclosure of assets, you're free to ask him about whatever assets he has. But why is that related to discovery?
Because at this point, Your Honor, in the motion, there's a pending application for prejudgment remedy against this gentleman.
Has it been granted?
No.
So we're a little...
Yes, Stephen, your assassins did not work. Not today.
Premature on the disclosure of assets.
I'm trying to recall. I know we had a hearing with Judge Graham the other day. Yes, and I'm not sure whether it's this case or another case that we agreed not to go forward with the PJR hearing. I'm not sure. So at this point, I think where he's from in a foreign country, how he's here, under what legal jurisdiction he's here, is all relevant, I believe, to him being here. It also goes to what extent does he know even the rules of the road of the state of Connecticut? Does he didn't have a license.
Well, you certainly can ask him that at a deposition, but let me hear from Attorney Akin.
Thank you, Your Honor. I have some relevant background for us. So first of all, this is still an application for a PJR, and whether any depositions are appropriate in that kind of a case.
Well, no. You have a pending civil action, so he's entitled to ask for any discovery he wants to ask for.
Okay, I'll backtrack.
Whether it's permissible is a different issue, but he can ask for discovery now.
Okay, thank you, Your Honor. So actually, we had a status conference with Judge Graham on the 30th for this case. That was last Thursday. And Attorney Brignall indicated he would be abandoning the PJR and serving a summons and complaint in order to make this an actual civil proceeding and a lawsuit against my client and the other people that were named in this application for PJR. And the reason that he's abandoning the PJR is because part of our discussions with Judge Graham included my client providing 2 affidavits, one of which was a financial affidavit regarding all of the assets that he has. And subsequent to reviewing the affidavit on the 30th, Mr. Brignall said that he would be abandoning the application for PJR. So all this talk of needing to know where he lives or who he is or whatever, I don't even understand it because my client has sworn under oath what his actual name is. And certainly Mr. Brignall can ask him for his name at his deposition, but to turn a deposition into an ICE inquisition is not appropriate. And that's really one of the bases for the motion for protective order. Number one is if you want to serve non-standard discovery and have my guy produce documents that are not subject to the normal standard auto accident discovery, you do that by way of non-standard interrogatories.
Let me just make sure I understand the procedural posture. So we're not even at the point where the complaint has been served.
Exactly, Judge.
Okay, so we're not at the point where any discovery is appropriate because he hasn't even been served yet.
That's correct.
So let's make this very clear and not waste more time on this.
This guy is so mad right now. You watch. He's so mad.
I'm going to grant motion for protective order. There's no basis to take any discovery when you haven't even served the complaint. So if Judge Graham, as part of the PJR process, had permitted certain inquiry, that's one thing. But we're talking about the standard rules. So there's no return date. There's no time period after the return date for commencement of discovery. We're way premature on all that stuff, number one. Number two, just so we're clear on what's going to be permissible going forward, if there is an affidavit from the defendant stating his name, that will be sufficient for you to know who he is. So should this come back to me, I'm not going to grant non-standard discovery unless somebody shows me that there's a basis for it, number one. Number two, we're not going to have, as I think Attorney Akin called it, an ice fishing expedition. Or I'm now calling it an ice fishing expedition. Okay?
Very well, Your Honor.
Anything else that was on the calendar for today?
Watch.
Nothing from me.
Okay, thanks, folks.
Thank you.
He's gone. He's gone before she
All
said
right,
thank you. He's gone. All right, we're gonna keep going with this judge for one more case that I think you're gonna like. I think you're gonna like it again. There's no it's just lawyer talk. It's just lawyer talk, but they're so good. Here we go.
Matter I had, do we have the lawyers here on Smith versus General Merchant?
Yes, Your Honor. Attorney Jared Alphin for the defendant.
All right.
Morning, Your Honor. James Sabatini for Ms. Smith. Also with us is Attorney Burrolino, but I was arguing something else at 9:30, but I'm here, obviously. So, Attorney Burrolino, you can drop off.
All right. Thanks, James. All right. So this is a motion for summary judgment. I have read the papers. Please keep that in mind. I'll hear from the movement.
Thank you, Your Honor. Again, you've heard our case before. You've reviewed the papers since then. We've done some depositions. As Your Honor can see from the papers, we obtained facts, and I think we're in no different position than we were before. The defendant's entitled to judgment as a matter of law. The firing or the termination in this case has absolutely nothing to do with gender, shoes, or an underwriting position. This was a situation where the plaintiff essentially sued my client in retaliation because my client, essentially, Mr. Clark, called her out in front of other people for failing to follow instructions and offered her the door for challenging her authority, his authority. And this is a person who has a history, as the deposition shows, a history of essentially leaving jobs because she thinks she knows better than her superiors. There's no constructive discharge here, Your Honor. She was going to be willing to take the job of an underwriter position, but she wasn't even qualified for that. And counsel wants this court to let the jury decide if she was qualified when, in fact, she didn't have a degree. She testified very clearly. I think Your Honor even asked that question the last time we heard summary judgment, and we've determined that now. So she had no degree. There's no underwriter position that was even offered to her. She didn't even apply for it. So she doesn't even get in the door on a claim for discrimination because she admitted she didn't apply for the underwriter position. The court should not overlook her insubordination. They should not overlook facts that Your Honor has in front of you. This is not a situation where the plaintiff has even remotely provided any basis for claim of gender discrimination with respect to her footwear. This is simply her walking out because she was upset with my client and the way he handled the situation. And that situation had absolutely nothing to do with gender. There's other women in the company. I think the facts establish that. And I think we're entitled to summary judgment. And I'd just like an opportunity to respond to anything that plaintiff's counsel has to say.
All right, thank you. Attorney Sabatini.
Thank you, Your Honor. The defendant had been moving for summary judgment on the basis that Mrs. Smith allegedly quit. We just heard from defense counsel, opening remark, she was terminated. Yes, she was. Their letter is a termination letter saying that she was terminated. This whole idea that she quit is false and serves as
among the issues of fact that the court has identified thus far in reviewing the papers was this issue of the plaintiff leaving work, and it's uncertain as to whether she's coming back, and then the termination letter follows, if I have the sequence of events correct.
Yes, Your Honor. I don't think it makes a difference.
It certainly does make a difference at the summary judgment stage. It's an issue of fact with regards to whether or not she, quote unquote, walked off the job or, in fact, was terminated. And she did not walk off the job. She didn't quit. She, in fact, was terminated under the circumstances as detailed in her written objection to the motion for summary judgment. This case is appropriately analyzed under the McDonnell-Douglas burden shifting test, and we walk the court through that analysis, especially in the supplemental objection to the motion for summary judgment that has the benefit of the deposition testimony of the owner of the company, whose testimony is in stark contrast to the caricature that this defendant is making Ms. Smith out to be. According to the deposition testimony of Craig Clark, she was a wonderful employee.
Okay, hold on a second. What? That sounds freaking awesome. Guys, listen to this. Oh, come on. I won't let me scroll up. There we go. KS just popped into chat and dropped a bomb on us. Hey, y'all, just got home from CrimeCon last night. Missed the chat while I was gone. What is CrimeCon, you think? Well, what do you think it is? Kelly asked. She got to the bottom of it. CrimeCon, like Comic-Con, only criminals? Yes. What? That sounds so cool. Wait, are you a criminal, KS? You have to be a criminal to get there, like Australia? Just kidding, Carolyn. That was a long time ago. We know. I want to go. He also said caricature. Isn't that like only when you draw someone? That's not when you talk about someone as something, right? No, don't try to walk it back now, KS. You're a criminal. You just said it. You just said it out loud. It is. It's a euphemism. Pause for a second. There we go. My computer's trying to keep up. It's a crappy laptop. I went to 3 different places today to get my computer repaired and no such luck. I have to actually send this back to the company that made the laptop. I mean, they made the computer. It's not a laptop. To do that, I have to call them first. And I didn't have time because, wait, KS says that met BTK's daughter, sat in the panel with Lori Draybell's sister, Rust movie attorney, and so much more. Oh my gosh. Yeah, that's true. Booty fish. That is true. All right. I remember how we were going to pick a city, guys. We are definitely going to Denver next year. We all are going to meet at CrimeCon. It's not old Big Booty Fish. I just bought it December 12th. It's brand new and it was pretty expensive. So they're going to fix it, I hope. 3 weeks, I think, is what I'm looking at. That's a guess. Anyway, it's not a laptop. It is a desktop. And it's a cyber power CD, cyber power PC. And what happened was I was in the middle of the stream and you guys saw it. First, my camera went out. Then I couldn't text. Then I couldn't talk. The stream was still going. And then I rebooted to see if that would fix it. And when I shut down, it never came back on again. So it turns on, but it doesn't display anything on a monitor. So I tried to switch the HDMI port. That didn't work. Yeah, that's true. I tried another known good monitor in both ports. That didn't work. I tried talking to it nicely, Mike. Maybe, I don't think so. So when I opened it up, the RAM on the motherboard, the RAM and the CPU buttons were lit up. So I reseated the RAM. That didn't work. I took out the CMOS to reset it completely. That didn't work. I took out the graphics card and booted it without the graphics card. That didn't work. So it's not the graphics card. So it is the motherboard. I'm sure of it. So I got to send it back. I have to send it back. And that's what I'm going to do. And then when I went 3 places to fix this stupid computer today, I had forgotten. I never lock my car, ever lock my car. It's never a big deal. I've forgotten. At some point during my crappy car's history, they had replaced the door handles. So the key that starts the car does not unlock the car. Well, my computer was in the car. So I locked the car when I got out of the car. Because the boy was hungry and there was a restaurant. So I'm like, hey, I'm just going to lock the car while we go in there. And then I got back to the car and I couldn't get in the car. So I had to wait for a coat hanger in the hot sun. And I wasn't able to get any further with my computer at all today. But I got better news. Starting tomorrow, but I don't know what time, so I shouldn't say starting tomorrow. Starting Wednesday, I should be able to triple the amount of courts that I can handle, that I can look through in one day. So we're going to get so many more good court cases every day. Like we've never seen this judge before. You guys have never seen this judge before. Every day I've been throwing up new judges every single day. I wasn't able to work on the ACA today, Kelly, because I was running around trying to get my computer fixed. So we're going to get more new. Yep. No, Fozzie, Okay, someone kick Fozzie. That's it. I've had it. All right, everybody who came here to watch court videos is gonna chew me out in comments. But that's fine. I'm fine. I love it. I love it. All right. Back to this. She got fired because she's a girl case. Here we go.
I just don't understand how the defendant thinks on this evidentiary record there isn't an issue of material fact as to whether or not the defendant's decision to terminate Ms. Smith's employment was motivated, at least in part, the motivating factor test, on account of her gender. So summary judgment should be denied.
Right. Very helpful.
There's no facts in the record that establish that my client in any way, shape, or form terminated her or she quit had anything to do with gender, her shoes, or anything else. She walked out.
But isn't there an issue of fact as to how she's characterizing what she was told by Mr. Craig and what he was saying to her?
No, because
how is that not an issue of fact? He's deposed and he says one version of reality. She's deposed and has another version of reality. And she's saying that he made an issue of it, whether she was wearing heels or not, or she wear sneakers or she was barefoot or whatever, to the extent that these are, meaningful issues. They've been highlighted by both parties, but I've got competing issues of reality.
Because I don't think whether she had shoes on or not, or what she was doing has anything to do with the basis upon which she's no longer employed.
She says it was based on gender, and she's using this as an example to say how she was treated based on her gender. That nobody else's footwear, particularly for men, was ever an issue in the employment, in the office.
Your Honor, the issue about the reason she was terminated has absolutely nothing to do with her shoes or anything like that. They had a dispute about office procedures, and she got up and she decided to leave because she didn't like the way she was called out. The shoes have nothing to do with anything other than she says that there was a comment about her shoes. That's not the reason why she was terminated or fired. In order to prove gender discrimination, you got to show that there were some facts that she was the adverse job action had to do with her gender. The adverse job action was she walked out because she didn't like the way she was spoken to, and she decided to leave, not because of her shoes or anything, but it was because of her ego being hurt and wanting to leave and not coming back to work. That had nothing to do with her shoes. They weren't even discussing her shoes. It's to try to bootstrap her shoes based upon comments made in the past to the fact that she left and why she was terminated or how she left to begin with. It's crazy. You can't bootstrap these facts because it would then lead down a very slippery slope where somebody could say in the future, "Oh, he made a comment about my bracelet," or "He made a comment about this." Oh, it has to be it has to be related to gender. That's why I'm no longer here. I think that we're walking down a very slippery slope. We have to focus, in my opinion, Your Honor, based upon the law. You got to show that there's an adverse job action and there was some discriminatory.
But she was terminated, wasn't she?
Whether she was terminated or whether she walked out, it doesn't matter. She's no longer there.
Doesn't it matter for determination of whether or not there was an adverse job action? If she quit, is that an adverse job action?
If she was constructively discharged, yeah, but there's no evidence of constructive discharge because she wanted to stay if she could have. So I think
I don't think that's alleged, is it? Constructive discharge?
It's not, but I'm trying to show
a gender discrimination case.
They can't even possibly get to right because they can't possibly get to constructive discharge anyway, even if they said, "Oh, she quit," because we believe that she was terminated. She walked out the door. She didn't come back. There's no dispute about that. And then the fact and why she left has nothing to do with gender. It's because she was upset the way she was treated by Mr. Clark. That absolutely about in following office protocol has nothing to do with gender whatsoever. And to go back in time to bootstrap a single comment in the history of their employment to say, "Oh, that was the reason why she was fired," that doesn't even make logical sense. And no reasonable jury is going to be able to find that there was discrimination based upon some comment about her shoes way back when or whatever. At the end of the day, she walked out. She didn't come back. She was terminated. It did not give rise to any implication whatsoever. She was the one that was upset. She walked out the door. And if you read her deposition testimony, which is cited, you'll see she has a history of challenging authority and not being happy or thinking she can do her job better than other people can. And this is just who she is.
Is that relevant for the court's consideration?
I think it is, because I think when you think about
Not that you think, but is there case law that you can point me to that says that I should consider that as part of the motion?
There's the case law I would say is Your Honor should consider the facts that are here, and whether a reasonable jury could conclude based upon those facts whether there's an inference or give rise to a motivating factor where gender was a basis for the discharge. And when you read those facts, Your Honor, this is a woman who was upset, who retaliated against my client because she walked out the door. She wasn't happy with the way she was treated. She was fired. It has absolutely nothing to do with her gender. Absolutely nothing. And if you read the deposition transcript, you'll see that they tried to throw in this whole thing about a junior underwriter position that she wasn't even qualified for. It's reaching and grabbing for straws that don't exist here, Your Honor. And
all right, thank you. I'll take the papers.
Thank you,
Your Honor. Can I briefly address?
No, I'll take the papers. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
I need a lawyer to tell me what that means. I'll take the papers. What does that mean? The summary disposition is going through? Is that what that means? I think that's what it means. I don't know though. He says that a lot at the end of cases. I'll take the papers. The guy who didn't show up for his $85,000 lawsuit, when he didn't show up, the judge said the same thing. I'll take the papers. So I think that means summary disposition goes through. Victoria, I hope you're having a good day off. I'm having a good day off. Me and Victoria are twins today because neither of us are working. No, I pity everybody who has to work today. You could just be home napping. You nap until you want to wake up, and then you wake up, and then you just nap again if you want to. All right, what did I miss so far? How long is it? Okay, this has already been an hour. I'm going to put Judge Fleischer on and try to get the rest of these tomorrow. We got the good ones. Oh, no, we forgot the love in jail one. No. There's lots of love going on in jail. The moms that love their kids that aren't allowed to go see them anymore and all that. But this is really, really love in jail. Here we go.
Okay, time will come. Much over he is. All right. Are you Edgar Lee Master? Yes, ma'am. So you're charged with battery and committing battery by strangulation. Public Defender's Office has appointed to represent you. All right, counsel, what's your probable cause argument for Mr. Laster?
Yes, Your Honor. Given the facts within the affidavit, Mr. Laster was not the initial aggressor in the situation. That goes to the battery. He was pushed 5 times according to the affidavit, and he pushed back in response 1 time. There is conflicting statements in regards to what happened after the initial push. However, the alleged victim in this case recanted her statement, stating that it was a lie and that she was intoxicated, and what she said wasn't true in regards to her being allegedly strangled by Mr. Laster. So that would be the probable cause argument.
All right, so he's charged with the battery and then the battery by strangulation. And it looks like Josephine McCrary, there are some acts leading up to her first, just there are some acts that happened. And it looks like she pushed him, and then he started choking her. All right, let me hear from you, Ms. Lewis.
Yes, Your Honor. A little bit of taking the affidavit before in accordance with the affidavit, the way the reasonable officer would, there is probable cause. I would point out that he choked her to the point of near unconsciousness, even at a stand your ground hearing, which they have not filed in this case a motion for a stand your ground. The act of choking her to near unconsciousness far outweighs a simple shove from the victim, and that is not a proper argument for Discrimination. While she might have recanted, it seems to be based on her displeasure with the outcome of the investigation, and her intoxication is also noted. But looking at the four corners of the affidavit, there is probable cause. Our OR am on the battery charge on the battery by strangulation, because I'm assuming that the battery charge is when he pushed her back, so OR am on that one. But the battery by strangulation, I'm going to set the bond at $2,500. He's to have no contact with, she wants contact, no hostile contact with the victim in the case. You're not to return, sorry, Your Honor, the state's just gonna object to no hostile contact and ask for no contact at all. We're close to the time of the incident. Choking somebody to the near point of unconsciousness is incredibly dangerous, and the state would ask for no contact in this case. You know what, that's probably wrong. We don't have her here, so I would say, she's there.
Yes, she's here, Your Honor.
She's here, guys.
So, they're both in custody right now, Your Honor. Obviously, the state's concerns are understandable. However, while they're in the Osceola County Jail, the chance of them having any aggressive contact or any extensive contact that may lead to any aggression is 0 to none.
Well, so let me have you have a seat, and let me have Miss Josephine McQuarrie at the podium, please. Sir, have a seat.
Yes, ma'am. And she's approaching now.
I just think it's so romantic when you dress like your partner. And they're there to get pictures. They probably already got their pictures taken. No, she's not in custody. She's dressing like her partner. It's romantic. It's a love story. Love.
All right, tell me your name, please. Josephine McQuarrie. All right, Ms. McQuarrie, you're the victim in this case, listed as the victim in this case. Do you want to have contact with the defendant? Absolutely. And you said in your report that he choked you to almost to unconsciousness. You still want to have contact with him? Yes, ma'am. So when that happened, when we fell is when everything kind of took place. We have a beautiful home together and children. We both have successful careers. We have no bias. I definitely want to have contact with him. All right, then. So you go back to where you were sitting and let me have Mr. Laster back up. All right, so Mr. Laster, I'll allow you to have contact, so you'll have no hostile contact. No hostile contact means no fussing, no arguing, no bickering, don't raise your voice. Y'all gotta live together like peaceful little lambs. Can you do that?
That's what we normally do. We've never had any issues.
All right, then. So no hostile contact, but y'all can't go back to the Gaylord Palms. No drugs, no alcohol, firearms, weapons, or ammunition. Good luck.
Thank you, Your Honor. If you're out second now, one statement, because I didn't want to talk about the facts. Sorry, I apologize.
Your Honor, would you like to add just a quick second? What did you say, sir?
And then I was just going to mention that I'm the victim on her charge as well.
Okay, do you want to have contact with her?
Absolutely. Yeah, I was going to say that the whole thing makes no sense. She's fine.
All right, and you want pretrial release? Yeah, I'm asking, did you want to add pretrial release with that? Okay. Thank you, I appreciate it.
So what is that?
$48,600 up?
$48,000.
No, I'm not understanding.
Who's denying
$48,000 over the limit? Oh, no, we're gonna have to get somebody to represent him. No, I'm not appointed for defendant on that. Yeah, no, you had him for just now, like for today, but you're gonna have to hire an attorney to represent
hire an attorney to represent you because you make almost $50,000 over the threshold.
What was that? I'm sorry, thank you.
This is case 24 and 1395. All right, Ms. McCrory, you were charged, you were arrested on a charge of battery and disorderly intoxication in a public place. There's probable cause to support the arrest. The public defender is not appointed. And I'm going to set your bond on count number 1, which is the battery charge, at $1,000, and for the disorderly conduct, the bond is set at $500. Pre-trial release supervision. No hostile contact with the victim, Mr. Laster. No fire, weapons or ammunition, no drugs without a prescription, and no alcohol. All right, good luck to you, ma'am. I'm sorry, did you say that I do have pre-trial release? It's just a bond in the amount of $1,000 on count 1 and $500 on count number 2. Okay, thank you. You're welcome.
Okay. I know I said that was the last one, and then I was going to go to Fleischer, but I lied. This is real quick. It's only a couple seconds long.
Questions as to your rights at this time?
The only question I had was, I signed into this tablet in the jail because I thought I did the judge hearing on this. Could that penalize me in any way? Like I was eager to get into jail, so that would screw the court hearing at all?
Since I have no idea what you're talking about, it's not going to play any role in terms of what we're doing right now.
Okay, sounds good. I'm good. Thank you.
All right. So.
That's the best question to a judge ever. Okay. Whew. Here we go. You guys ready? It's time. It's absolutely time. Oh, I think I have to answer some questions. And I don't know the answer, but that's okay. No, I don't know if Judge Fleischer streamed today on his YouTube, but I don't think so. But I could be wrong because I was running around locking my keys in my car. Victoria, you have no idea how quiet that courtroom is when you were gone. You were gone on Friday. It was like crickets. You're going today. It's like crickets. But Melissa's doing such a great job. Yep. No. Okay. It's official. He didn't stream today. He will, guys. He will. Hi, Fletcher. But until then, here we go. It's time. Look at him. He looks so good. That's me. Wow, that looks packed.
Luis.
Oh, it's Louise. Oh, Victoria. That female interpreter is so good. She's so good. She was on Friday? Was it Friday, guys, or was it Thursday? I don't remember. Oh, all right. Sorry. I should put this up here. I'm gonna get the link to Judge Fleischer's YouTube channel. Or you can just go to YouTube and type in Justice with Judge Fleischer. I think. Hold on, I'm going to tell you exactly what it is in a second. Finding Justice with Judge Fleischer. I'm going to put the link in here. All right, there's 85 subscribers right now. And within the next 5 minutes, from everybody here, I know a lot of you are already in there, but I want to see 100. Okay, I'm going to put the link in right now. And I want to put it up on screen. Now, I didn't see any comments while I was doing all that. So I'm just going to tell you again, Victoria, that girl interpreter was so good. So good. I loved her. What did he say, guys? Right. He said, right. And she said, I don't know, bien. Or whatever. It was so good. Oh my gosh. We stopped it. We rewound it. We played it again. Listen, does she have black hair, guys? I don't know. Or blonde. I don't know. Somebody tell her. You guys all watched yesterday. I was looking at comments. Don't worry. Don't worry, Victoria. They're going to tell you because they're good. They know. But let's go. Let's get up there. Irma. Her name is Irma. She was so good. I have an aunt, Irma. She's not fluent in Spanish though. Okay, guys, 5. We only need 5 more people to subscribe to get to 100. Come on, guys. Show Judge Fleischer the love he deserves. I'm not going anywhere until 5 more people. Just subscribe real quick. Oh, it's still 95. That didn't work. That didn't work. What I said didn't work. Okay, I know that most of you are already subscribed. I realize this because we did this yesterday. It's still all right. Maybe we'll get there today. We will. We'll get there today. And Victoria, we love Luis. We absolutely adore Luis forever and ever and ever and ever and ever. We're not saying Irma is better or worse. We loved her saying 96. 4 more. All right. Back to the judge. He hasn't done anything yet. Here we go. Let's make him earn his pay for today.
Thank you. Please.
So quiet. It's packed.
Give me a second.
2 more people, guys.
Judge, page 22 for Owen.
Yeah. Are you ready?
1 more person.
Ready?
We need 1 more person. Can I get a witness? Can I get 2 witnesses?
Frederick Owens. Mr. Owens, you're charged with 2 cases. You're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. You're also charged with displaying a fictitious counterfeit or inspection sticker. On that one, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews of the state of Texas. Speaking out for the lawyer, a lawyer will be appointed to represent you, sir. Okay.
Judge, on May 25th, 2024, a traffic stop was conducted on the vehicle for a vehicle with no front Texas license plate. Officers contacted the insurance provider of the insurance given by the defendant. The insurance company advised that the insurance policy does not come back to the defendant nor the defendant's vehicle. Furthermore, while removing the defendant from the vehicle, he had a handgun, a Smith & Wesson between his legs. Further, there was a holster in his waistband.
But the gun wasn't holstered.
Correct, Your Honor.
Okay. All right, Mr. Owens, I'm going to find that there's probable cause to go forward with your case. Tell me, do you have a Texas driver license, sir? Do you have valid liability insurance in your name? I want proof before you leave here today to make sure before we allow you to drive. Do you understand? What do you do for a living?
I actually just got laid off at Veterans Plus and now I'm full-time school, going to Lone Star right now.
When did you get fired?
It was right before the beginning of May, so the end of April. It's been right around April school year. But then when we got let off, just because they closed down 2 of the stores, the one in the Woodlands and the one in Tomball, and so they just didn't have the hours for me.
How are you supporting yourself now?
I'm just full-time student collecting disability from the government.
What's the nature of your disability?
Depression, anxiety, night terrors, pancreatitis, and pain above my knees and ankles.
And do you actually get paid by the state for this?
Yes, sir.
How much do you get a month for
I
that?
get 2,200 a month.
2,200. Did you want to apply for an appointed lawyer, Mr. Owens? Okay. I need you to fill out an application for me because I don't have one. Be honest on the application. I need to know everything about you, what kind of car you have, how many cars you have, any kind of property that you own. I need to know everything. Deputy Bo's going to give you the application. I'm going to have you go to Ramona, sign a receipt, and then I'm going to have you take a seat in the jury box. I want proof that you have actual liability insurance in your name before we allow you to drive today. I'll have you speak to a lawyer, and then through the lawyer, you can achieve that from us. Okay? Please.
Presa.
Am I bringing him up?
¿Me acomodo? Señor Presa.
Presa.
Pase, por favor. Mr. Arango Orlaza. Señor Mario. ¿Qué tal, caballero? Parece aquí en el centro. Solo mire el juez y le contesta nada más en español.
Osvaldo Presa.
Yes.
Mr. Presa, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews of the state of Texas if you cannot afford a lawyer. A lawyer will be appointed to represent you, sir.
May 27, 2024, a traffic stop was conducted for a vehicle failing to drive in a single lane with other vehicles on the roadway. Another vehicle was observed pressing on their brakes to avoid a collision and flashing their high beams at the Silverado to gather its attention. Defendant had red, glassy eyes, slurred speech, and strong odor of an alcoholic beverage coming from his breath. The defendant stated that he had consumed 3 12-ounce Coronas. SFSTs, 6 out of 6 clues for HGN, 6 out of 8 clues for walk and turn, 4 out of 4 clues for one leg stand. DIC was read, consented, revoked. He consented, then he revoked his consent. Blood warrant was issued, and as Your Honor already stated, he has a previous TWI in 2019.
But have you run an NCIC to see if you have any other DWIs elsewhere?
I have not.
Mr. Presa, I'm going to find that there's probable cause to go forward with your case. Do you have a Texas driver license?
No.
You are not allowed to drive. Do you understand?
Yes.
I don't care what's going on in your life.
Oh my goodness. I turned my back for 1 second. And Lewis comes in. Okay, Lewis, I said that I liked her. I didn't say she was better than you. You are amazing. Is he really here? Is Lewis really here? Or am I just crazy? Someone tell me. Where is he? Hi, Simple Auto. Hi, Carolyn. Hey, Kelly. I'm looking. I don't see anything, guys. Did I miss it? Oh, he watched. I get it. He watches chat replay. Lewis, you've never heard us say anything bad. We love you. We think you're awesome. We really do. But if you would have seen her yesterday and you would have heard her say, you would have laughed because it was so good.
If I find that you drive, I will have a contempt hearing. You'll be facing 6 months in jail every that you drive. You're now, because it's a second offense, will be ordered to get a handheld interlock device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If you consume alcohol, likewise, you will go to jail. If you're not in this country with permission, you're pushing your luck.
Con su suerte.
Do you get it?
¿Usted lo entiende, señor?
Sí.
Yes,
Are you in this country with or without permission?
without permission.
What happens if you go to jail?
What?
What happens if you go to jail?
That's a deportation. I'll get deported.
Right.
Claro, cierto.
Are you married?
¿Es casado?
Contado. Unión libre.
Together, we have a child.
How many kids you have?
¿Cuántos hijos tiene usted?
Dos.
2.
What happens if you go to jail for a year and they have no father
No tienen ni
and no wife around, husband's wife? What's gonna happen?
¿Qué va a pasar?
No van a comer, no.
They're not gonna be able to eat without a father.
No.
No.
They're gonna go look for support wherever they can find it. Same with her. And I tell you what, it might not be a place that you like. Consider that next time you make a move while you're out there in the free world. One more false move, I'm gonna keep you with me. Do you understand?
Yes.
You will be randomly tested for drugs and alcohol. Because you have a lawyer, I will waive your appearance, but it's your responsibility to stay in touch with Mr. Sparks. If he tells me that he can't get a hold of you because you're playing games, likewise, I will revoke your bond. You will not get any more PR bonds from me. So any more alcohol, and the worst thing you could possibly do is get into a car and drive. I don't care what's going on in your life. Do not drive.
¿Entendió? Sí, señor o no?
Sí, señor.
Yes, sir.
We'll have you come up here, swear to us that you're not going to drive. I will have you go to Ramona, sign a reset. After that, you'll get with Tracy for your bond conditions, and after that, you may go. Thank you, Mr. Sparks. Portable, yeah.
His shirt said best time of your life.
You can leave that there. You can leave it, waive the fee, and he gets a portable device as well, because I want to make sure that he's not going to drive anyways. I'll waive the fees, Mr. Sparks, so he's not at, you know.
Prior to speaking morning, he drove his vehicle down here. Is it possible he can drive it home? No?
He doesn't have a license. Absolutely not, no.
License start like they ordered it to do by the day, which is in compliance with, and he's in compliance.
Mr. Sparks, he doesn't have a license. I would be telling him that he can violate the law. How do I even know he reads English to read the signs? You know, I'm not gonna allow him to violate the law.
So we're gonna have to make some arrangements to have.
Yeah, he's gonna have to have someone else drive it. I mean, imagine this. If I were to say yes, he goes out and kills a family of 5 on the way home. It's my name on that. I don't want that. You know? Yeah, it's not. He knows that he's not supposed to drive anyways. He was in here a year and a half ago, 2 years ago. Same thing. This is not the first time. I remember him. Yeah. I had the same thing with him not 2 years ago. Now he's back.
A lawyer just asked the judge if he will grant permission for someone to break the law. And the lawyer thought this was a great idea.
Yeah. Hi, come on.
Good morning, Your Honor. May we approach?
So quiet in there.
Chantella Sheldon. Ms. Sheldon, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, ma'am. Okay.
Judge, on May 27, 2024, officers observed a black Buick traveling at a higher rate of speed than the officer and the other surrounding vehicles. The vehicle was weaving and failing to maintain a single lane, almost striking 2 vehicles. Traffic stop was conducted, and upon approach, the officer observed the defendant as the driver, and there were 2 other passengers, one in the front passenger seat and one in the rear passenger seat. Officer observed that the defendant to have a strong and distinct odor of alcohol beverage emitting from the vehicle. She had glassy eyes, slurred speech. Officers relocated the scene to Academy Parking at 2404 Southwest Freeway in Harris County, Texas. SFST's HGN was 6 out of 6. Walk and turn, 5 out of 8. One leg stand was 2 out of 4. DIC 24 was read. The defendant refused, and blood warrant was executed. The defendant presented a Louisiana license, Your Honor.
The next question, and then if you can run an NCIC, what other, if any other priors does she have, please? Ms. Shelvin, I'm going to find that there's probable cause to go forward with your case. You live here in Houston, or you live in Louisiana? How long have you lived in Louisiana or in Houston? Are you planning on staying here? Then you must surrender that license and get a Texas driver license.
I actually tried to get a Texas license, but I was denied because I had a vehicle at the time, and they said I had to have my vehicle registered prior to getting a license or something. However, I didn't do the steps correctly, and they denied me the Texas license.
It's time for you to do whatever you need to do to get that license. Otherwise, I will bar you from driving.
Yes, sir.
You have liability insurance in your name.
I don't have a car. I drive one of my passengers.
And I'm not to drive now. You understand? You don't have liability insurance that's in your name for whatever car you're going to drive. I'm ordering you now not to drive at all. You understand? I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond. I will put you in jail. You will not get any more PR bonds.
Speaking of PayPal, thank you, Fozzie. Thank you so much for your pre-order of our excellent shirts. And I just spoke while I was in this stream with, I sent them a message while I was in this stream about the shirts, and they asked for a change, and I sent it to them yesterday. So I just asked them, and I sent them an email to see, an update. So, Fozzie, maybe you'll get your shirt soon, sooner than you think.
You understand?
Yeah, they're in custody.
No, because she's going to be monitored with Tracy. You don't need to. This is an affidavit that you're going to promise us that you're not going to drive. I don't care what's going on in your life. You cannot justify getting in a car and driving for any reason. Do you understand? If you drive, it's going to go sideways real quick. You're going to end up in jail. And if you have no one to post a $5,000 to $10,000 bond, what happens? Stuck like Chuck. Have you come up here, swear to us that you're not going to drive? Tell me, what do you do for a living, man? How many kids you got?
She sells burritos sometimes.
How do you get money? How do you
They
get
didn't take care of me.
Burrito.
My children dad take care of us.
What kind of income do they have?
I mean, he works for a private company that does have HVAC work.
Okay, we're going to reset your case to give you time to hire a lawyer. I will have you come up here, swear to us that you're not going to drive. We'll get you to Ramona where we're going to be signed a reset. After that, you'll get with Tracy for your bond conditions, and after that, you may go. Please.
This is on the RO again. Got the motion done,
Okay.
and then just reset. That's what make sure he's my client's.
Yeah, he's free to go.
Thank you, Judge.
For sure.
Please. Do you solemnly swear affirm the information stated in this document is true, correct, to the best of your knowledge? You also swear that this is your signature and no one else's. You swear you will also play the vehicle. You will then see the large issue reset.
Stephen is doing such a good job. Did you see that, guys? Did you see Stephen working hard in the background? Why is everybody so quiet? It's really creepy. I mean, he does say, guys, keep it down, I think. But look at them. Look at them. This is not normal. Victoria, he has friends in low places. It checks out. You know, a good person would have edited this part out, which I really thought I did.
Judge, are you ready for another arraignment?
Yeah.
We were all thinking it, but no one was going to say it. And that Melissa, too. Hi, Melissa.
Judge, is Sheldon reset for THA or?
Yeah. Mr. Thompson.
Yes, sir.
You, David Glenn Thompson.
Yes, sir.
You were charged with driving while intoxicated. Second offense. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Your Honor, on May 26, 2024, officers were dispatched to a minor crash located at 4500 Brady Street, Harris County, Texas, in which the defendant's vehicle, 2022 Mitsubishi Outlander, struck a parked vehicle. Upon arrival, officers observed the sole occupant, the defendant, in the driver's seat. Also observed the defendant to have glossy eyes, and observed the defendant to have 6 out of 6 HGMs. Defendant admitted that he was driving and stated that he was leaving home and heading to a restaurant. The defendant stated that he had not had any alcohol on that night. Officers observed the defendant to have glossy eyes or slurred speech, an odor of alcohol emitting from the defendant's person and breath when the defendant spoke. Officer administered the FSTs. The defendant got 6 out of 6 HGM, 4 out of 8 walk and turn, 4 out of 4 one-leg stand. The defendant, DIC 24 was read.
Joey, I'm so sorry.
Results, 0.186 and 0.182.
Mr. Thompson, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
Not in my name, no, sir.
We're not allowed to drive.
Yes,
I'm
sir.
now having you sign an affidavit with me today, promising me that you're not going to drive. If you drove here today, you may not drive home. Do you understand?
Yes, sir.
Because
Joey, Carolyn went on an ice expedition earlier. So if you need ice for your bumped head, she can help you.
it's a second offense, I'm ordering you to obtain a handheld interlock device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If you have a drug or alcohol problem, you better address it, because if you don't, I'm going to do it for you. And I promise you, you're not going to like the way that I do it. Do you understand?
Yes, sir.
You will be randomly tested for drugs and alcohol. Any violations, you will go to jail. You will not get any more PR bonds, sir. I'm gonna have you come up here, swear to us that you're not gonna drive. I will get you to Ramona where we're gonna be signing a resit. We're gonna get you out of here to hire a lawyer. After that, we will get you to Tracy where you will get your bond conditions. And after that, you may go. When you come back, please have a lawyer, sir. Come on. Yeah, it's just handheld device. No, 3 days, please.
I'm so confused right now.
Really?
Yes, sir, can I please explain?
Yes, Mr.
Okay.
Mireles.
Yes, very much so, because whenever I left here, I went downstairs and I thought the ankle monitor would be put onto me downstairs. Nothing was put onto me, but the hair center showed up. I went directly from here into custody with the hair center, and I've been at the hair center. On the 13th, I was still at the hair center, apparently when the warrant went in for my arrest, and I was still with the hair center. I got released from the hair center because I found housing. I've left the hair center, and then I got picked up on the street because I got a little kitten from my PTSD. She went in between a fence. I go over the fence to get her. When I got her back into her kennel, and I had my kennel with me when the officers was checking me. I had no drugs, no nothing. And then they said I had a warrant, and I was very confused because I haven't done anything. And at the Harris Center, I was with them the entire time. I told them about the ankle monitor to please check on it, and they said they would get a hold of me, and if there was, they would set me an appointment to go get it. Nothing was ever done. And if you could please call the Harris Center, they'll tell you what I'm telling you is the truth. I haven't done anything.
I got a different report.
From who? From the Harris Center?
Did we not, Lori?
We did.
Okay. You know that you're telling me something over here.
I promise that's exactly what happened.
I got
Melissa, that's
information
you
from
over
the Harris
there,
Center
Melissa.
themselves that says it's over here.
What? What did they
You
say?
didn't go turn yourself in. That you didn't go do what you're supposed to do.
I did. I was at the hair center. I've been there. I was at the hair center.
Contact to see if the hair.
Please, yes. April is my care worker. April's my care worker. She'll know.
Hold on.
I don't understand how that's possible.
I don't want to keep you in jail for the sake of keeping you.
No, I know, sir. I've been doing good. I've been doing everything. I've been trying to make you proud. I did what you said.
See?
I promise.
You're going to reach out to the Harris Center.
I promise. I swear.
Verify.
April knows who I am. She's my care provider. I have all my paperwork. I have everything.
Okay. Hold on a second. So.
Thank you.
I have him back for a second. Take your time.
Legal, I want you to fess up. I want to know, Legal. Look on the screen right now, Legal. Everybody look on the screen right now. Is that Legal Fiction standing there? Is it? Is it him? I think it's him. I think it's him. He's only coming in now because he finally got out.
Time. There's no rush. Deputy Bodie, we're going to check now, Mr. Mireles.
Okay.
We'll see.
Okay.
I'll bring you back out when we have a result.
Thank you for listening.
Of course.
Issues with the storm going out the power, so it's financial issues with work. Caused me some issues, but I came to ask, is it possible I can pay the restitution on the case?
No, this is interference to the duties of a public servant.
Correct.
There's no restitution on this
Okay, I talked with some lawyers about that, and it was a.
Look, my only question to you is, do you have a lawyer today? I'm not here to negotiate your case. We're not here to work it out. None of that. You need a lawyer to represent you in this case. That's the only thing that matters. Do you have a lawyer? Okay. What are you doing about that?
That's what I was trying to explain. It's another case that's involved in this matter that I have to hire another lawyer on, another case. And that's why I say it's a conflict of interest that people don't know the details of the matter. So with me coming today, I'm asking you, can you appoint me a lawyer on top of that because I can't afford a lawyer to hire for both cases in this matter.
Do you have another criminal case that's open?
No, this case involved an accident. And that's why I said I can't speak of the details here in court. But there's another case along that lawyers need to be hired for.
What do you do for a living, sir?
I'm a CNC operator.
Okay.
Proceedings.
How much money do you make a month?
$35,000 to $4,000.
You don't qualify for an appointed lawyer, sir. Poverty, you have to meet the federal poverty guideline, and which is a good thing for you. You make quite a bit of money. You need to hire a lawyer in this case. I will give you more time. I will give you another 30 days, but I don't give out court-appointed lawyers like it's candy. It doesn't work like that.
I wasn't saying that. I wasn't saying that, Your Honor. I was saying I can't afford one, but the reason of that, the reason of the accident of my vehicle getting totaled, which is part of the case, I'm paying to have to go back and forth to work for that. That's why I'm.
Mr. Cato, I don't want to talk to you about the case.
Yes, sir.
You don't qualify with as much money as you make.
Yes, sir.
That's it. I don't have an unlimited number of lawyers. I work for Harris County. They don't give me everything I want. I wish I had a ton of more resources. I just don't. I will give you another 30 days. I will have you go to Ramona, sign a receipt, and we'll get you out of here, sir. There's a gajillion and one lawyers in Harris County. It's a matter of you going online, finding one. 99% will put you on a payment plan if you ask, where you pay a couple $100 and then they'll represent you. So, if you get a lawyer that charge you $7,500, go to the next one. There's always a lawyer that's willing to represent you. Like I'm telling you, 99% will put you on a payment plan. Don't take them at first blush. Negotiate with them. That's what you can do. Well, I can give you this much now. I can give you this much later. This is what it should, There's 10,000 lawyers in Harris County. There is one for you. It's a matter of you finding it. All right? Please.
Judge, the next one is Clark on page 6.
Well, I'm sorry, Ramona, what was the last name?
Cooper, Shannon Cooper on page 9.
Mr. Cooper, do you have a lawyer today? Tell me what you're doing about that.
Trying to make sure everything for, storm everything, having me sit back.
Okay, you want a little bit more time?
Yes.
Okay, we'll give you another 30 days. It's already 47 days, sir. Do you have a Texas driver license? It's probably now suspended or going to be near suspended. So you're supposed to have a lawyer.
Driving, as you said, so it's.
Hold on, let me make sure. Okay, right. There's a no condition drive, so make sure you don't drive.
And then it took effect on work also, so.
Got it. Okay, please. We'll give you another reset.
Wrong one, Judge. Trade.
Oh, that's a big difference.
Judge's favorite judge is Simpson, though. Oh, that's scary. Look what he's doing.
Hi, Antonio.
Good morning. This is a plea on Ismael Miranda.
I don't know. Mr. Miranda, we in Harris County, we lead the nation in fatalities related to drunk driving cases. We actually have a case today here in this court where a defendant was charged with driving while intoxication and a death occurred, and now they're probably going to end up charging him with intoxication manslaughter. We have one here today. And here you are. You were charged with your first driving while intoxicated on April 21st. My guess is that he got out, didn't come to court, and now he picked up another DWI.
He does have an immigration.
And I will tell you that, had you done things the right way, you probably either would have gotten this thing dismissed or you would be out in the free world. Now, because of the moves that you have made, not only do you have 2 open DWIs, but immigration now has a detainer on you. You are stuck. And now you will probably just end up getting deported. Did you secure a time served?
I did, Judge, on one, and the other one is being dismissed.
I don't know if I can do that. I mean, why on earth would we reward this gentleman with the time served when he's picked up 2 DWIs?
Right now he has 35 days credit on this case that he's pleading to, so that would.
Did he actually do 35? He has 35 actual days done? Tell me, how is jail?
It's not pretty. Mírenlo a él, no acá, a él.
Why is this fair?
¿Por qué crees que eso es justo?
You've been busted twice. How many times have you not been busted?
¿Cuántas veces no lo han agarrado a usted?
How is it fair that you get to endanger 4.5 million people?
Peligra 4.5 millones de personas.
How is that fair?
Justo eso, ¿cómo es justo?
Luckily,
por suerte,
no one is dead.
Nadie está muerto.
I will tell you now that you will probably end up getting deported because of this. You coming back to this country illegally. If the feds catch you, it's a minimum of 5 years in federal prison. When you do things the right way, Mr. Miranda, good things happen. I promise you, when you do things the right way, good things happen. Don't endanger my public. If you ever come back here, don't get into a car. Don't come back the wrong way. You get permission before you come back here. And I'm going to tell you, if I see you again here, I will bring the pain. Mr. Miranda, you're charged with 2 counts of driving while intoxicated. Looks like you secured an agreement where they're going to dismiss one in exchange for your plea on the other one. From now on, you will be facing a minimum of 30 days in jail. Wait, which one are we going on? Oh, we're going on this one. Okay, on the actual 35. So what this means, guys, keep it down. You were enhanced to a minimum of 90 days. If you ever pick up another DWI, it's a minimum of 90 days in jail. A third, you're looking at prison time, 2 to 10 at the penitentiary. With your record, if you ever get pulled over in a car, an officer's going to look you up. They will immediately put you in jail. If you even have the faintest smell of alcohol. Don't endanger my public. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law, you give up the right to appeal. Once you accept this agreement, you can never come back and change this, challenge this. You understand, Mr. Miranda?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I will find it true. I will sentence you to 60 days in jail. I will give you credit to the 35. It's true that you had a prior, or that you have a .15, is it not?
What was that last question?
It's true that you had a breath or blood alcohol concentration of a .15 or above, is it not?
¿Es verdad o no es verdad eso? ¿Es verdad o no es verdad?
Okay. How do you plead to the offense of guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to suspend your ability to get a license for 2 years. Do not try. If I see you back here, I'm going to lose my license. Do you understand?
Perder la cabeza. ¿Entendió, señor? Sí, sí. Yes, sir.
All right.
That's your honor.
2 years. Yeah. Thanks.
Siga el oficial.
Carolyn, you don't mess anything up ever.
Delandria Burnett.
Yes, sir.
Ms. Burnett, you're charged with 2 cases. You're charged with theft. You're also charged with failure to identify oneself. On the failure to ID, you're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement where they're offering you 30 days in jail, credit for the 22 days that you've done. Is this what you want to do, ma'am? Understand this charge will go on your record. It's going to be there for the rest of your life. You can never take it off. You'll be facing a minimum of 90 days in jail if you ever pick up any more cases. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You can never take this off or complain about this in the future once you plead guilty.
Yes, sir.
This is what you want to do. How do you plead to the offense, man?
So the face ID, guilty.
I will find you guilty. I will follow the agreement. Your theft case will be dismissed on motion of the state. Good luck to you.
Thank you.
Thanks. Thank
Thank you,
you.
Ms. Lauren.
Yes, sir, Your Honor. You want to talk about the motion to withdraw Mr. Jose Torres.
Bring him up.
Yes, sir. Mr. Torres, step off, please. So this is what happened. Just give you a little input of what happened. I had him in my office yesterday. We watched the videos and stuff, and he told me that I told him the options that may be available, that he may be eligible for PTI. I told him that that with PTI, there are certain provisions that he would have to comply with. One of those of which was that he would have to have an toxilizer on his car. And if he did not have a car, he would have to have a portable device. He was not amenable to that. So that took the PTI out of the question. I told him that you would have the opportunity for probation. He said that he thinks he's innocent and he was not amenable to probation. I told him that, I have already told you that if you take this case to trial, that fee is going to be different from that for not going to trial. And he said that he believed he was innocent, that he was going to take it to trial, and he asked me to give his money back that he gave me yesterday. He had given to me yesterday. I gave it back to him. That was it.
Give him everything back?
I gave him the money that he paid me yesterday. I gave it all back, $500. Gave it all back to him. So.
I mean, this case is now, it's 180 days. It's time to make a decision. It's now, we set up for trial now. So if that's what you want, we will set up for trial now. You have 2 options. The option you have is pleading guilty to the case. Have you offered time served on this case?
Yes, Your Honor.
On Torres?
3 days.
Okay, and they've offered you time served. However, with that option, it'll go on your record. You'll also incur a license suspension. You'll also have a probation officer option. If you don't want either of those 2, then we just set it for trial. but you need a lawyer to represent you. You have now Mr. Dixon represents you.
Yeah,
It's too late.
Like Mr. Dixon stated, we did talk about my options, and I just asked him a question and said, you know what, okay, I'm gonna give you the $500.
Look, it doesn't,
Yes, sir. Yes, I would like to go to trial, yes.
I will tell you now that if you do go to trial and lose, you'll be facing a minimum of 30 days in jail. You were enhanced with your prior theft. I don't know what happens in trial. We never know. Some witnesses are good, some witnesses are bad. Some officers testified greatly, some officers testified just very, very poorly. You never know what happens in trial until you actually get into trial. I do know that, like I said, though, if you go to trial and lose, you'll be facing a minimum of 30 days in jail. That's a minimum. So, far be it from me. Problem is that it's 180 days. We set up a trial now. So, and as it stands, he's now representing you here. So
Yeah, we had a misunderstanding.
I don't want you to make a decision now. If you want, we can give you time. I can have you guys step in the back. You talk with Mr. Dixon to see if that's what you really want to do. I don't need you to make a decision right now. We need a decision today, but it's still early. Did you watch the videos? No. Did you watch the videos?
Yes, sir, I did.
Because before you really set things for trial, because I don't play games. I don't, if you want to set up a trial, great, but I'm not going to take any deals once you set up a trial because I don't like to play games. And
believe me, I would never play with something this serious, I just don't,
the only thing is you need to make an informed decision.
Yes.
The only way that can happen is if you've seen the video and you've seen yourself.
Yeah,
You don't have to justify it because
saw the video.
that's what's going to happen in trial. A jury of 6 people will look at that video and they will determine, because common sense rules, common sense dictates.
Yes, sir. Yeah.
So let's do this. Just step back for a bit, talk, tell me what you guys want to do, and we'll go from there.
Yes, sir.
Please.
Yes, sir, come on.
Judge, we still have 4 seconds.
Let's get the lawyers out and then we can do it after. I don't know, we've got a whole line of lawyers over there. James?
2 of my interns. Judge, I'm just here for appointments. I'll stand by for appointments.
Okay, Alberto Garcia, come up. Mr. Garcia, do you have a lawyer today?
No, sir.
What are you doing about that?
I'm trying to get one as soon as possible. The storm and financials has set me back and not having a
If you
job.
one more reset, your case is old.
Yes, sir, I know.
By the next setting. Do you understand? Okay, come on.
Can I go talk to you on?
Mr. D.
He's adamant about going to trial.
Okay.
So quiet. It's just so quiet in there today.
I'll talk to you in a second about it.
We need a sob sit with a taser. That's what we need.
With regards to this,
Mr. Salim?
It's hilarious because I was standing outside of my car today, can't get in, and my son is with me. And he's scrolling through YouTube on his phone. And all of a sudden, he stops at this video about, oh God, who was the founder of Subset? I can't remember his name. Anyway, out of nowhere, he doesn't know what a Subset is. My son has no idea. But the video is like how not to pay income taxes or something like that. And he starts playing this crazy about how we don't have to pay income taxes and how he won all of his cases because there's nothing in the IRS that says you have to pay income taxes. My son, who's right beside me, is listening to Subset bull right beside me, like I'm not even there. And so I had to yell at him, but it was fun yelling at him, so it's all good.
Right here. Morning, sir. Mr. Adrian Salinas, sir. Can you get your signature? He's calling your signature to Adrian. Trying to run over with you.
Can I get a witness?
Oh, I don't know. Do you have a plea?
Yes, Judge.
Probably.
Okay, yeah.
Probably yes. I'll be happily wrong. I've never been wrong before, so though I wouldn't know.
Salinas. With a C? Yeah, S. Salinas. Salinas.
All right, Mr. Salinas, you're charged with 2 cases. You're charged with possession of marijuana. You're also charged with possession of a controlled substance. You've worked out an agreement where they're offering you 3 days in jail, credit for the 2 days that you've done on the possession case. In exchange for them, they're going to dismiss the possession of marijuana case. Is this how you understand it? So you're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this.
Yes, sir.
Understand from now on, you're facing a minimum of 90 days in jail for any cases you may pick up. You want to do this?
Yes, sir.
How do you plead to the offense, sir?
Yes.
I will find you guilty. I will send you to the agreement. Good luck to you, sir.
Thank you, Your Honor.
Yeah. Tell me. Are they unopposed? Okay, I'll sign it for you. For sure. All right, Ramona, who's next?
Hill. Kathleen Hill.
Kathleen Hill, come up.
She's Kathleen. She's innocent. Innocent. I tell you, innocent.
Good morning.
What are you today?
I do not.
Tell me what you're doing about that.
I'm still working on it. I was working.
What do you do now? How do you support yourself?
Just there's a hit out for my life, so I'm in fear of my life. So I'm unable to go to the place where I was employed.
So
Now I'm just.
have you taken? Have you not called the cops?
I have.
And
I don't have their direct names. It's a offense that was something that happened to me. I'm sorry, I'm so nervous.
It's okay.
Something that happened to me. The person that done these things to me, they're being charged with murder, and so their family is retaliating against me. I don't have the direct names, so it's just It's just a hard
Let me see.
thing.
And if you'd like an appointed lawyer, I need you to fill out an application for me. Deputy Bill will give you an application, then I'll have you go to Ramona, sign a receipt, and then I'll have you take your seat in the jury box, man.
Well, Reese, first off, let me say I am never late, ever. I can absolutely tell you exactly what time my lives start because they're the same every day. All right, just listen to Fozzie. They're 4:30 a.m. Eastern Standard Time, maybe. Maybe. But if you're in my Discord, then sometimes I'll let you know if maybe I'm gonna be late. Maybe. Sometimes I tell you at 4:35, hey guys, I think I'm gonna be late. Listen, Fozzie, remember that time you slept through my stream a couple times? Okay. All right. 4:30 a.m. Yes, sometimes I start 3 streams. Ramona, keep everybody in line. Work hard. Be good. Have a great, great, great day down in Texas or up in Texas if you're watching from Mexico. Yeah, 4:30-ish. 4:30. We're going to go with 4:30. Guys, we're going to go with 4:30. Here we go. Let's finish, Judge. He has 12 more minutes before he's done for today. Well, not really. His stream was too long. So I did 12 minutes and 25 seconds more, and I'm going to play the rest later, I promise. I wasn't able to play Friday's full stream because that's the computer it's on that computer that broke. So, but I gave you the rest.
Judge Jackson, you're ready for the next one.
Okay. Yes.
As soon as we find out what shoes she was wearing, we'll find out what happened to the kitten.
Come up, Mr. Jackson. Do you have a lawyer today?
No.
What are you doing about that?
Trying to get one.
Okay. Do you have a job? Why not? Are you chewing gum? Please spit it out.
I was gonna get a job.
Right here. Keep your hand on the ball.
Back like you got all this swagger. Yet with all your criminal history, can you even get a job? Truly, can you get a job?
I don't know. I guess so. I don't know.
When's the last time you tried to get a job?
Yesterday,
Doing what?
in New York.
Do it. You get a job, you prove it to me that you got a job, and that doesn't pay much, I'll happily give you a lawyer. But I'm not going to give you a lawyer while you're doing nothing, man. Just bumming out and getting to play Xbox all day. Why do Harris County get to pay for a lawyer for someone who gets to do nothing, play Xbox, and smoke weed all day? Doesn't work like that. Get a job, show you got one, and I'll give you a lawyer. Do you understand? Get a job.
Judge, the next one is Jenkins, Christina Jenkins.
Hey, do you want me to sign this or keep the paper one? Because I can sign it electronically or we can do that.
Did you sign that?
I did, but I don't care, whatever's easier for you.
I'll just delete it.
Believe? Okay. Ms. Jenkins, do you have a lawyer today?
No,
Tell me what you're doing about that, man.
I'm trying to get one. I'm in the process of moving, so it kind of took from my funds in the storm.
Guys, look. She looks so nice for court. Guys, someone dressed up for court.
Okay, so we give you more time, you'll have one? Okay, ma'am. If you're gonna go on to Ramona, we'll have you sign a receipt. Yes, ma'am.
I'm going to find that guy for you guys. I'm going to find him. I'm going to bring him back up. I'm getting it now. I'm getting it now. I'm getting it now. All right, here we go.
Right, or follow.
Now, since I have no idea where he is, we're going to find him together. There's the first time we saw him. I missed him. Okay, we're going to reverse. We're going to reverse it. We're going to reverse the whole feed. Maybe that was the second time. Sorry, that was my bad. Okay, this is the second time we see it.
Mireles.
We'll find out in a second.
I will, but I want to know from him, how's the
Chad's here.
process?
Hi,
And then
Chad.
does he stay there? And then we'll see. Connor. Hey, talk to me.
Gillian Salmeron on the docket.
Okay.
The textbook bail review, we went away.
Oh, that's right.
It's 2003. She has a felony bond at 10,000. She's not gonna be able to afford either.
I'm not, I mean, I can't give her a PR bond.
No, I'm not.
I just know that she's not going to do.
I let her know that that's not what's gonna happen today. But yeah, I really, the problem is her felony
Let's do
set
this.
so far
Let's do
out.
this. I'm going to bring her out because I want to talk to her. I don't want her to just languish in fear of like nothing's going to happen. So let me bring her out and talk to her for a minute, and then we'll figure out.
Yeah. The other side.
Have you spoken? Let's see, who's the felony? Do you know who the felony lawyer is?
No.
I don't either.
But the thing is, Judge, I'm feeling that it's a felony trespass only because it was during a state of emergency, so it was made a felony. I didn't know that that's how that works. And then the other is the PCS.
I'm scared for you, both of you. And Ramona. I'm scared for all of you.
And then I'll bring her out next and then we'll figure out. Okay. Mr. Mireles. So when you get there, what's the situation when you get there? You're housed and you stay there, correct?
When you get there, they only have, where I was, jail diversion is about 14 days at the most. If you're active and you're searching, which I was, if they see that you are actively searching and doing what you're supposed to be doing, they can help you if they don't find housing for you in between those 2 days. I was managed to find housing, so they gave me my discharge paper and I was able to leave to go to my housing. Which is temporary.
Lies the problem.
You deny.
You're supposed to stay.
Too strongly.
You're not.
They tell them when they can leave.
Yeah, they discharge you.
They discharge you from the Harris Center. He got discharged because he got housed.
Yeah, and I got housing, so I went to my housing. I might have lost my housing now because of this misunderstanding, but I can go back to the hair center and have them re-help me again to get back, because it's a volunteer.
The housing that you're going to.
The housing that I was at was in the Heights, and it's
Living with who?
I stayed with my younger sister first, just to she's pregnant, but it's not with her anymore. I was going to be staying with the what is it called? I forgot what it's called.
So the housing you basically get to choose. Is that what you're telling me?
No, sir. You have to apply to them, and it's called Magnificat. Magnificat is who I was going to be staying with. It's called Magnificat Housing, and they only provide you for 8 days, because this is a transitional housing. This is to get you into a place as best as they can. It's not permanent, but it's transitional. You go with them, you stay with them, and you get you hopefully into something in between to be permanent.
So that's the long term.
They don't do permanent at the center. If you want to get permanent housing, you just have to hopefully keep staying with.
It's gonna happen after 8 days.
Happen
after 8 days.
You pretty much as long as you keep doing what you're supposed to be doing, you can stay with them. And that's what I was doing. I'm doing what I'm supposed to do, as long as they show that you're out looking for jobs, you're out looking for housing, you're doing what you're supposed to be doing, not just abusing the free housing. Then they'll work with you to get you into another one as fast as possible, or to stay with them longer, because they don't like it's.
I'm able to verify that you're actually staying in a place.
I can keep in touch.
I'm not going to take your word for it.
So,
I need to speak to someone to know what you're doing, where you are. I'm not going to take your word for it.
I can keep in touch with you. I can just have someone from the hair center. His name is Greg. Greg is who's helping me get my housing.
If I remember correctly, and I might be wrong, this is the guy where the judge called the dad, right? This guy said he was going to go live with his dad. The judge called the dad. He said he hadn't spoken to his son in years. He just calls when he needs money. But this guy stood there and told the judge that he was just going to live with the yeah. Judge isn't going to believe anything he says.
I can keep in touch with you. I can give him your number, or we can have everything.
His phone number.
Everything I have is in my paperwork, and they took everything. When they arrested me, they took everything away from me. I had nothing. I couldn't get anything. The only thing I had was my little cat that they took from me.
Don't worry about a cat at this moment.
No, she's in my
About
PTSD.
yourself first.
Well, she was recommended. I got her because I have bad PTSD, so they recommended I go get a PTSD animal, and I got him.
Are you telling me that where you're going to go for 8 days, they're going to let you have a cat?
Yeah.
Yes,
it was their idea. It was their idea to get a PTSD animal, because I have very bad PTSD. So I went and I adopted a little kitten, and he helps me a lot. He's the reason to stay in good shape, to get everything together. He's beautiful.
I commend you. I just want to know.
He means a lot to us. I mean, he's very beautiful. You should see him. He's like my everything, and they took him away from me. That's the only reason I want to get back out there right now. He's at the SPCA, and I don't know why they took him from me.
I understand.
He's really beautiful. He's a little gray kitten. He's awesome. His name is Green Beans. I promise I was making you proud. I was doing everything to make you proud. And I had to get back out there to get him. And I want to get back into housing. It's tearing me apart to know that they just ripped them from my hands like they did. And I was doing everything that I was supposed to do. I don't want to lose them.
All I want to do is just verify what you're telling me.
I promise. When I get to the center, I can have, because that's the only place I can go. I have to go back to the center because I can't lose my housing. I can go back to the center, and I can have April call you immediately, get in touch with you. She was actually.
Mr. Mireles, listen. I want them to contact Lori.
Okay.
As long as we can verify you're doing, know where you are, where you're staying, and that you're not out on the street, I'm happy.
Okay.
All I want to know is that you're not on the street.
No, I'm not. I'm not on the street at all.
I know you're gonna tell me little bunnies jumping in the woods.
No,
but it's not. I've been through this before.
They can verify I'm not, because the second that I am on the street, I go straight to the hair center. I don't want to be on the street. The hair center is amazing. It gives me great food, housing, everything. And the whole point of it is to get out of homelessness. That's why I'm doing this.
That's
I
why
can't be on the street.
have you here.
Yeah.
Because from what I understand, you took off, and that's not what I want to happen. I want you to stay in touch with Lori.
Okay. I told you so much. My cell phone got stolen literally just.
You're not listening.
Okay.
Stop and listen.
Okay.
I want you to stay in touch with Lori.
Okay.
And I want Greg to be able to verify with her where you are at all times.
Okay.
Lori is pretrial.
If
Who's
in
Greg?
8 days I don't hear anything, because I'm writing everything down that you're telling me. In 8 days I don't hear anything, a warrant will issue. I'm not going to play this game with you again.
Yes, sir. I understand.
Melissa is writing everything down that you're saying.
Yeah. Okay.
Before you leave the jail, you will have an ankle monitor on you.
Okay. That's fine.
You must stay in touch with Lori.
I will. Yes, sir.
This is it.
Okay.
So redo the PTI to release to the hair center again?
Release to the hair center, same gig
I
as,
was
as
wrong.
last time.
Not
No
pretrial.
release on his own to the hair center with a GPS.
Okay.
All right.
Pretrial.
Hey. Make me proud.
Tracy is pretrial.
See it. Go get your kitty and make me proud.
Oh.
Okay. Yeah.
Judge, the state has.
Oh, we did it, guys. We made it to the end. And I can't. There we go. We made it to the end. We made it to the end. Thank you so much for coming out. Now, if you're here for the videos, you can go now. You can go now because I have no idea what my chat's going to say. Maybe nothing, and I'll end it. Or maybe something, and I'll keep going. However, I am going to Discord after this. I'm not even getting up. I'm just going to go to Discord. So if we want to keep the conversation going or talk about something else. Yeah, legal. That was pretty good, wasn't it? Get your kitty and make me proud. Yep, go back to the beginning. You're going to get mad at some point, John. Dude. We're not stuck like Chuck in handcuffs. Oh, no, we're not. We're not letting Victoria get a cat. The kitten's fine. Bye, Kelly. Thank you, love. Victoria, don't get. They will. I had no cats when I started doing this, and now I have 9. I don't know how many I have. I'm not going to count now. Yeah, there you go. She's strong. She's a strong, independent woman. Oh my gosh, guys. Fozzie's back. It's about time you get to work. After all you make me do every day. And we're just waiting for Amazon or Walmart. I can't remember who I ordered it from. Delivery. And then I will be able to get so many more videos. So many more videos. I'm so excited about today. Hi, Irvy. Oh my, I cut my dog's hair today because my air conditioner doesn't work. So I have these little fake air conditioners in the house, but my dog was hot. So zoom, I cut off her hair and she looks so freaking cute. And she's so soft. And you heard her because I don't yell at her for barking because I love it when she talks. Yeah, honey, I miss most of my clips too with this chat. Cats are squishy except for their nails. No, I don't think so, Legal. I think he's hungry. All cats are hungry. They are only hungry. My cats will bring balls back to me, though, if I throw them. They'll play fetch with me. Then they'll scratch me. But that's fine. It's all love. I have an orange one that sheds like crazy. It is one of those little $30 air conditioners. And you put water in the top, and then it blows the water out. And it's not really an air conditioner. There's no like coils or anything. Your cat's name is Atari. That's awesome. I absolutely miss Atari most from my childhood. That's the thing I love the most. Then I had in television where I played Pitfall. Doo-doo-doo, doo-doo. If anybody ever played Pitfall, you know that noise because it does it the whole game every time you swing. Well, it's not working. It's working fine. It's fine. Everything's fine. I had it on television. Come at me, Fozzie. I know I had it on television. I don't know. They're coming out with a new Diablo. I'm going to be playing that. I bought the new Harry Potter game, and I think I played it for like maybe an hour. And that's crazy because, I'm a huge Harry Potter fan. Not a J.K. Rowling fan. Just, I have a Commodore 64. Oh, you gave your daughter an Atari. You must love her. Me and Fozzie going toe to toe. Now I'm going to start Googling it. I'm going to start Googling everything. Carolyn. Yep. Okay. Chaw's right. Chaw's right. I got to go set up for courts, but I am going to. Oh, that's a good one. I've never had an Amiga 500. E2, Brutus. E2. I remember my Intellivision, the controller had this disc on it, not like a joystick, like Atari, round disc, and it fell into my chicken's corn. No, it was Mrs. Grass. Remember Mrs. Grass soup, or with the little tiny little noodles? I love the shit out of my daughters too. My Intellivision fell right into my soup when I was playing my Pitfall game. Oh, no. Victoria has to spend the whole week with her kids, though. You're going to be begging to go back to work by the end of today. That's it. I've had enough of this house. I'm going back to work. I horse fish. I know the day my computer broke down, I was ready to go back to work. I just was like, I'm done being home. I just want to go back to the restaurant and wait on tables. And that night, I think I got on stage because they got the words wrong. So I helped them. Yes, I did. Yes, I did. Yep, played Frogger so much. So much. I know. Oh, you adopted Atari and they had a PlayStation and Xbox. I never heard of a Nintendo Game Watch. That would be crazy to play a little watch all day. At the end of the block, when growing up, we had a donut shop, donut go round. It's not there anymore. And I used to go almost every single day with quarters and play Miss Pac-Man for hours and hours and hours. And yes, Space Invaders, that was my Atari. Miner 49er. Oh, it wasn't watch. It wasn't watch size, guys. I'm just an idiot. Yep, I just drank with my microphone on. Come at me. Go ahead, come at me. Look at General. I can't turn on Discord right now. Obviously, it'll make that beep, 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 beep noise that everybody doesn't like. And my laptop may or may not be able to handle that. Yeah. Yeah, I hear you, Victoria. I hear you. I used to be a administrative assistant many years ago, and I know how much work you have to do to keep that thing running. You and Melissa. He gets all the fame and glory because of his bow tie, which is so cute. And his bracelet is so cute. Hi, nurse. Hello, nurse. I don't believe you. Okay, I'm telling you, I got it on a television. I got it on a television. It was awesome. Poor nurse. Hey, nurse, it's over. We're all going to go hang out in Discord except for Fozzie. He's going to bed. He's had enough. He always goes to bed when I go to Discord. Actually, have you two ever seen me and Fozzie in the same room at the same time? Uh-huh. Yep. Think about it. No. Don't. Oh, Fozzie's working. I have an hour before court start. I'm interested in Connecticut again. I think I'm going to go get some Connecticut, even though it was boring lawyer talk today. Judge Frost was on again today, but nothing happened. So I love Judge Frost. I love his courtroom. I love how he works. I love everything about him. Space Invaders. It was like Space Invaders, but different. Oh, I know what you're talking. It's not Centipede. You're not talking about Centipede, are you? They didn't shoot you, but you got to shoot them. So, Carolyn, I'm going to show you what I got. I'm going to show you the answer to that question. Carolyn's asking if there's any Alaska courts. So, I'm going to show you what I got. And I'm embarrassed at how often I try this, even though I never get anything. Okay, so here's my list of Alaskan courts. Okay, so we have all the cities. All right, I know for a fact when I started this channel, I was getting some Alaskan courts. I remember getting them. The volume was so low that I had to stop because you guys wouldn't. I played a few and chat crucified me in chat. Like they really did dislike the audio from Alaskan courts, like really bad. So if you look, every time I go here and I look at all live streams, okay, there's all the streams. These are both online and offline streams. And there's plenty to choose from. Plenty. I mean, plenty. This is why I tell you guys, I could put a new judge on every day. I have so many sites like this, but Alaska's not a good one because every single time I go to just all live streams, boom, nothing comes up anymore. Nothing. And guys, before you say it, I do understand the time zone in Alaska. So I check during that time zone. I promise. But nope. Plus, I'm scared because if I put another Alaska stream on, oh my gosh, you have no idea how bad the comments were last time I did. It was so bad. I used to play Pac-Man. All right, I'm going to hop in Discord and shut this down. If you haven't yet, hold on, I'm going to try one more time. Oh, hold on 1 second, guys. It's important. History. Hold on, just give me 1 more second. It's important. It is important. Oh my gosh, it's not in my history. I only need one more second. Finding Justice with Judge Fleischer. I'm giving you the link. I'm going to give you the link. Make sure you're subscribed. So it's only up to 103. If you have not subscribed yet to Judge Fleischer's new channel, I don't know when his lives are going to start, so don't ask, but they will. And let me put this on the screen. Make sure you subscribe. I mean, it doesn't hurt to subscribe. It just doesn't hurt. And then you'll know when he goes live. And you can stop asking me because I have no idea. I'm not subscribed. Just kidding. I subscribed right away yesterday. Yay, John. You can't beat your sister at all, Cha. You're not allowed to do that. You're not allowed to beat your sister. Although she's on my list. If I ever go to jail, it'd be for family violence. And my sister is way up at the top. All right. All right, guys. Thank you for coming out. I appreciate it. Behave. Come to Discord if you want to keep talking. Or you want to show your pet off, or you want to show your crafts off, or you want to show a video, or you want to look at some memes, or you want to yell at Fozzie. Victoria wants to see how good his channel is before she subscribes. Make him earn that subscription, guys. Oh, no, don't behave. Go to Discord, and I will talk to you guys again soon. Thank you so much for coming out, guys. I appreciate it. I really, really do. See you soon. Goodbye.